There is a war being fought right now that most of the financial coverage is missing entirely. It is not the war over tariffs. It is not the war over semiconductors. It is not the war over who controls the chip supply chain, or the electric vehicle market, or the South China Sea. It is a legal war fought in federal courts and in the chambers of the United States Supreme Court over a single question that determines everything else. Does the President of the United States have the constitutional authority to impose the tariffs that are currently holding the entire US-China trade architecture together? And by every available legal measure, that war is not going well for Washington. On February 20th, 2026, the Supreme Court ruled 6-3 that the primary legal mechanism Trump had used to impose tariffs on $175 billion worth of imports. The International Emergency Economic Powers Act is constitutionally invalid for tariff purposes. Take a moment to absorb what that actually means, not as a legal technicality, as a strategic event. Here is what is actually at stake across every dimension. The February 20th ruling Learning Resources Incorporated v. Trump decided 6-3 did not merely strike down a particular set of tariffs. It struck down the constitutional theory that underpinned the entire executive tariff program. The argument that a president can declare an economic emergency under IEEPA and use that declaration to impose tariffs on any trading partner at any rate, indefinitely, without congressional approval. Chief Justice Roberts wrote the majority opinion, joined by 5 justices across the ideological spectrum: Sotomayor, Kagan, Gorsuch, Barrett, and Jackson. The ruling was unambiguous. The power to impose tariffs is a taxing power. It belongs to Congress under Article 1 of the Constitution. The President cannot unilaterally claim it through emergency declarations. The immediate financial consequence, approximately $175 to $179 billion in annual tariff collections, the revenue generated by IEEPA tariffs, was declared constitutionally invalid. Gone. Trump's response: a 10% global tariff imposed under a different legal authority. Section 122 of the Trade Act of 1974. But Section 122 has a statutory 150-day limit. That clock is running now. Simultaneously, the USTR launched a sweeping set of Section 301 investigations in March 2026, targeting 16 economies for excess industrial capacity and 60 economies for forced labor violations. The stated goal: complete these investigations by July 24th, before the 150-day clock on the Section 122 tariff expires. Today, we are going to break this down the way it deserves to be broken down, with the actual numbers, the precise mechanisms, and the specific legal timeline that no anchor on cable news is explaining clearly. If you want to stay ahead of this story as it develops specifically, whether the Section 301 investigations survive their own legal challenges, whether Trump reaches a deal with China before July 24th, and what happens to markets if the entire tariff architecture is struck down. Subscribe to Nexus Report right now and activate all notifications. The hearings begin April 28th. The deadline is July 24th. The Supreme Court may be watching this case again before the end of the year. We are tracking every court filing, every hearing, every diplomatic signal in this story. Subscribe now. Let's go through this completely. The first dimension is constitutional. To understand what February 20th actually did, you need to understand what IEEPA was and what it was not designed to do. The International Emergency Economic Powers Act was passed by Congress in 1977. It was designed to give the President authority to regulate financial transactions, freeze assets, and impose targeted economic restrictions during genuine national security emergencies. It was used appropriately to freeze Iranian assets after the 1979 hostage crisis. It was used to impose targeted sanctions on specific individuals and entities implicated in terrorism, drug trafficking, and state aggression. It was not designed as a tariff mechanism. The word tariff does not appear in the statute. The word tax does not appear in the statute. What the statute says is that the President may regulate importation during a national emergency. The Trump administration argued that regulate importation includes the power to impose tariffs. The Supreme Court, 6-3, said, it does not. Chief Justice Roberts' majority opinion was explicit. The power to impose tariffs is very clearly a branch of the taxing power. Taxing power under the Constitution belongs to Congress, Article 1, Section 8. The President cannot acquire it through a statutory reinterpretation of a 1977 emergency law. The framing of a tariff as an emergency regulatory measure does not change what a tariff is: a tax on imports, collectible at the border, generating federal revenue. That is Congress's domain. The practical consequence of this ruling was immediate. Approximately $175 to $179 billion in annual tariff revenue collected under IEEPA authority was declared constitutionally invalid. Importers who had paid IEEPA tariffs became entitled to refunds. The legal machinery for those refunds began operating the moment the ruling was issued. But here is what most coverage missed in reporting this ruling. The ruling did not merely invalidate these specific tariffs, it invalidated the constitutional theory. It established that no president, this one or any future one, can unilaterally impose tariffs at scale without congressional authorization. The executive tariff power, as claimed in 2025 and early 2026, no longer exists. This is not a policy setback, it is a structural constitutional realignment, and its implications extend well beyond this administration. The second dimension is legal vulnerability. The Trump administration's immediate response to the IEEPA ruling was a pivot to alternative legal authorities. A 10% global tariff was imposed under Section 122 of the Trade Act. Broad Section 301 investigations were launched across 16 economies. These moves were framed as aggressive countermaneuvers, evidence that the administration had other tools and was not deterred. What the framing obscured is the legal vulnerability profile of those alternative tools. Section 122 imposes a hard one, 50-day statutory limit on its authority. The tariff expires unless replaced. The Section 301 investigations, therefore, must be completed before that expiration by the 24th of July, 2026. The USTR has described this as an accelerated timeline. What that means in legal practice is that they are compressing a process that normally takes 12 months into approximately 4 months, and doing so in a legal environment that is now actively hostile to executive tariff authority following the IEEPA ruling. Here is the mechanism that no financial news desk is naming plainly. The Retail Litigation Center, a legal arm of one of America's largest retail industry coalitions, has filed an amicus brief in HMTX Industries LLC v. United States, urging the Supreme Court to review not just IEEPA tariffs, but the Section 301 tariff expansion that covers virtually all Chinese imports. The legal argument is specific and structural. USTR originally imposed Section 301 tariffs on $50 billion in Chinese imports through the full statutory process, 12 months of investigation, public comment, hearings, proper procedure. Legal. But USTR then used Section 307 of the Trade Act, a modification provision, to expand those tariffs from $50 billion to approximately $500 billion in Chinese goods. A tenfold expansion, without going through the full Section 301 investigative process. Without the 12 months of procedural safeguards Congress mandated, Consumer Watchdog has filed a separate amicus brief making the same argument. More than 4,200 cases have been filed in the Court of International Trade, raising the identical legal challenge. 4,200 cases in one court, raising one question: Did USTR have the authority to expand Section 301 tariffs by a factor of 10 using a modification provision that Congress never intended for that purpose? If the Supreme Court grants certiorari on this question, and the volume of cases and the amicus activity suggests, it is considering it the entire $500 billion. Section 301 China tariff architecture faces the same constitutional exposure that destroyed the IEEPA tariffs. The backup plan has a backup problem. The third and deepest dimension is Beijing's strategy. China has watched the IEEPA ruling, the Section 301 scramble, and the legal siege being mounted against the administration's tariff architecture, and it has drawn a precise strategic conclusion. Within days of the IEEPA ruling, China launched 2 counter-investigations into U.S. trade practices, targeting American policies it claims have disrupted global production and harmed Chinese companies across new energy industries. China's counter-investigations are not defensive legal maneuvers, they are signals. They are China telling Washington, "We have read your ruling, we understand your legal architecture is in transition. And we are positioning for the period after the transition, not for the period before it." Here is the strategic calculation Beijing is running. The US-China trade relationship, from China's perspective, has passed the point of bilateral negotiation and entered a new phase: managed economic decoupling. China stopped buying US exports in April 2025 following the first tariff escalations. US goods shipments to China have fallen to levels not seen since the 2008 to 2009 global financial crisis. The decoupling, from Beijing's perspective, is already operational. The legal question of whether US tariffs are constitutional is, in strategic terms, almost irrelevant to China's planning horizon because they are building the alternative architecture regardless. The Belt and Road Alternative Trade Network, the BRICS payment settlement system as a dollar bypass mechanism, the Petro-Yuan agreements with Gulf states. These are not reactions to tariffs. They are the strategy that tariffs accelerated. Beijing's current negotiating posture, counter-investigations, refusal to return to pre-tariff export levels, continued development of alternative trade corridors is designed to exploit precisely the legal and political window that now exists in Washington. The IEEPA ruling created a period of tariff legal uncertainty. The Section 301 deadline creates a 4-month window in which the administration's leverage is legally contested. China's calculation: use that window to advance the alternative architecture. Let the American courts do the work of dismantling US tariff leverage, then negotiate from the position of an economy that no longer needs the American consumer market as urgently as it once did. What the mainstream financial coverage is completely missing about this situation is the relationship between the IEEPA ruling and the Section 301 legal vulnerability, and specifically, what it means for markets. The financial markets have not priced the Section 301 legal risk. Read that again. The $500 billion in Section 301 tariffs on Chinese imports, tariffs that are currently embedded in the pricing structures of virtually every US retailer, manufacturer, and industrial company, that sources from China are the subject of more than 4,200 pending legal challenges in the Court of International Trade and an active amicus campaign urging Supreme Court review. 4,200 cases in one court, raising one question: if the Supreme Court grants certiorari on HMTX Industries and rules that the Section 307 modification expansion exceeded statutory authority, the tariff architecture does not merely shrink, it reverts. $500 billion in tariffs reverts to the $50 billion scope that was originally investigated properly under the full statutory process. The markets are not pricing this scenario. The S&P 500's current valuation embeds a tariff on China baseline that assumes the $500 billion Section 301 framework, remains legally intact through 2027 and beyond. If the Supreme Court issues a cert grant on HMTX, even just a grant, before any ruling, analysts estimate a repricing event in sectors most exposed to China trade: retail, consumer electronics, industrial manufacturing, semiconductor supply chains. This is the specific financial mechanism that the $175 billion IEEPA revenue figure understates. IEEPA tariffs generated $175 to $179 billion annually. Section 301. Tariffs at the $500 billion scope generate significantly more, and they are embedded at the company level in pricing, inventory decisions, supply chain restructuring, and capital allocation, in ways that a sudden legal reversal would disrupt catastrophically across entire industrial sectors. The Federal Reserve is watching this. When they cite trade policy uncertainty in their minutes, this is the specific uncertainty they are referencing, not the policy debate, but the legal architecture debate. A Supreme Court ruling that strikes Section 301 tariff modifications would force the Fed to reprice its inflation models, its growth models, and its interest rate trajectory simultaneously. This is what nobody is saying plainly. The real risk to the US-China trade relationship is not that tariffs stay too high. The real risk is that they collapse suddenly, legally, and without sufficient lead time for markets, companies, and supply chains to absorb the adjustment. Let us examine with genuine analytical precision what happens across the three realistic scenarios over the next 90 days. Scenario 1, the most likely path, carries a probability of approximately 55%. The Section 301 investigations proceed on their accelerated timeline. Written public comments due April 15th are processed. Hearings begin April 28th at the U.S. International Trade Commission. USTR completes its investigation by the July 24th target date and announces new Section 301 tariffs on Chinese goods, replacing the IEEPA-derived tariffs that were struck down. The new tariffs are immediately challenged in the Court of International Trade. Legal proceedings begin. Given the current volume of pending cases, more than 4,200, and the precedent created by the IEEPA ruling, the challenges receive sympathetic treatment from the courts. A stay of the new tariffs is sought. The administration opposes it. This scenario drags the entire trade war into a prolonged legal attrition that plays out over 2026 and into 2027. Markets adjust to what analysts will describe as elevated but legally uncertain tariffs. Companies that had already reshored or nearshored supply chains benefit from the uncertainty. Companies still exposed to China face a new planning horizon: comply with current tariffs under legal challenge or wait for courts to resolve the question. Watch for this signal: the first court filing challenging the new Section 301 tariffs. It will arrive within 48 hours of any tariff announcement. The speed of that filing signals how organized the legal opposition has become. Scenario 2, legal reversal before July 24th, carries a probability of approximately 30%. The Supreme Court grants certiorari on HMTX Industries LLC v. United States before the Section 301 investigation is completed. A cert grant, which requires only 4 of 9 justices, signals that the court believes the Section 307 modification expansion raises a substantial constitutional question. The administration would face immediate pressure to seek a stay of existing Section 301 tariffs pending the court's ruling. If no stay is granted and the full hearing proceeds on the current court calendar, a ruling could come by June or July 2026, potentially before the Section 122 backup tariff expires. A ruling striking Section 307 modifications would revert $500 billion in China tariffs to the $50 billion original scope. The market impact of this scenario would be acute. Equity markets in consumer, retail, and manufacturing sectors would reprice within hours of a ruling. The dollar would face pressure. The Federal Reserve would face a decision: interpret the tariff collapse as deflationary relief or interpret the supply chain disruption as inflationary shock. Watch for this signal: any Supreme Court scheduling activity on HMTX Industries. The court's case management list for the October 2026 term is where this signal would appear first. Scenario 3. A bilateral deal before July 24th carries a probability of approximately 15%. Facing legal uncertainty and the Section 122 deadline, the Trump administration uses the Section 301 investigation as leverage to negotiate a bilateral trade agreement with China before July 24th. This deal would give both sides an exit from the legal and economic uncertainty. The U.S. agrees to modify its tariff demands. China agrees to resume purchasing U.S. goods and to structural concessions on intellectual property and industrial subsidies. This is the scenario that most benefits financial markets in the short term. It is also the scenario that requires the most from both sides domestically. Trump must explain why he is negotiating away tariffs his administration described as essential, and Xi must explain concessions to a domestic audience that has been told the trade war is a triumph of Chinese strategic patience. Watch for this signal: a quiet announcement of a U.S.-China bilateral working group or economic dialogue before June 1st. Deals of this type are always preceded by weeks of preparatory technical meetings described as consultations, not negotiations. The linguistic shift from consultations to dialogue is the signal. The Supreme Court did not rule on trade policy. It ruled on something deeper. It ruled on whether executive power has legal limits that cannot be bypassed through emergency declarations, whether a president can, through creative statutory interpretation, acquire the constitutional authority of Congress simply by naming the moment an emergency. The answer, 6-3, was no. That answer has been given before, in other eras, with other names. In 1952, the Supreme Court told President Truman he could not seize American steel mills during the Korean War, even under wartime necessity. In 1974, it told President Nixon he could not withhold evidence under executive privilege. The pattern is consistent across 70 years of American constitutional history. Power exercised beyond its legal architecture does not collapse immediately. It functions. It generates revenue. It reshapes supply chains. It restructures economies. And then, when the person holding it needs it most in a trade negotiation, in a crisis, in an election year, the legal foundation gives way. Watch the Court of International Trade. Watch the July 24th deadline. Watch China's Belt and Road investment announcements. They are the real strategic clock in this story. All sources are available in the description. Verify every figure for yourself. History does not repeat, but it rhymes, and those who cannot hear the rhyme are always surprised by what comes next.